Now, I am going to dictate a legal passage at the rate of 120 words per minute. 5, 4, 3, 2, 1. Let's start. It is submitted by the learned advocate for the petitioner that the mere fanciful wish of the minister in charge cannot be a ground of urgency for acquisition of land. The subjective consideration which prompted the minister in charge housing department to acquire the land through a shortcut method of section 17 within bracket 1 is required to be stated in the notice for requisition under section 4 of the said act for consideration of the general public and specifically the land losers as to whether the application of section 17 within bracket 1 in acquisition the land was fair and justified. Learned advocate for the petitioner further submits that section 17 of the Act 1 of 1894 gives a special power of the appropriate government to acquire any land needed for public purpose in cases of urgency on the expiration of 15 days from the publication of notice mentioned in section 9 of the said act. Therefore, in case of an urgent acquisition of land, the appropriate government is under obligation to issue a public notice under section 4 within bracket 1 read with section 17 within bracket 1 of the said act. At the same time, the appropriate government shall also cause notice to be given at the convenient places on or near the land, stating that the government notice to take possession of the land and that claim to compensation for all interests in such land may be made to him. In the instant case, the petitioners were not served any notice under section 9 within bracket 4 of the Act 1 of 1894. He also refers to another decision of the division bench of Allahabad High Court in the case of Ajabdul Bugs and others versus state reported in EIR 1982 11-435 to satisfy this court that the state respondents have failed to place any material to show as to why all proceedings of section 5A were dispensed with and no objection was allowed to be submitted by the persons interested against the proposed acquisition. It is also submitted by the learned advocate for the petitioners that the petitioners did not know till date as to whether any award in the form of compensation has been paid. In respect of the aforesaid land acquisition proceedings initiated under Act 1 of 1894, the petitioner never received any notice to receive any award under the said act. In view of such circumstances, if at all the court decides that the acquisition proceedings was lawful and proper, the petitioners are entitled to get an award on determination of compensation. Under section 24 within bracket 1 within bracket small e of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013. Learned advocate for the state respondents on the other hand submits that the writ petition filed by the petitioners is absolutely speculative and liable to be quashed in support of his contention. It is submitted by the learned additional government pleader that in paragraph 2 of the writ petition, the petitioners specifically stated that the land in question was in use and occupation and possession of the petitioners since long back. Stop.